I recognize Representative Sabourin Deschenais, please.
Thank you, Chairman Lynn. Thank you all for having me again. I'm excited to introduce this bill this afternoon. I think it's going to be a good conversation. We have a lot of folks that are here to testify on this. I encourage you to listen to everyone. This is HB 1825, what I like to call the Freedom to Practice Law Act, a new initiative for our state. There's a lot of technical drafting in this bill, I want to say, and I'm grateful for OLS for their work on that. But the policy goal of this bill is simple: to treat the legal profession the same way we treat every other licensed profession in New Hampshire that falls under the purview of the legislature. Let me tell you where this bill came from, the inspiration. I watched someone represent themselves pro se in family court. Years of litigation, years of learning the hard way, and I thought, why couldn't the worst years of this person's life become training for a new career, perhaps? Why couldn't real-world experience count for something the way it does in our Learn Everywhere program for students? And that's the inspiration. And here's the problem it addresses. According to the American Bar Association, New Hampshire has 2.47 attorneys per 1,000 residents, the lowest in New England. Maine is next at 2.65. This is an access to justice issue. 90% of family court litigants in New Hampshire represent themselves pro se. That's not a system working well. New Hampshire is not alone in looking at reform. Texas and Florida have recently ruled that their state bar associations no longer have final decision-making authority over who can sit for the bar exam. Additionally, California, Washington, Virginia, and our New England neighbor, Vermont, all offer law office study programs, which are apprenticeships where someone works under a licensed attorney or judge for 4 years and then sits for the bar. No law school required. So here's what HB 1825 does. First, it establishes multiple pathways to licensure: traditional law school, apprenticeship, or direct examination with supervised practice while maintaining competency standards. Second, it opens the bar examination to the public. Anyone can take the exam for credentialing purposes, even without seeking licensure. This includes minors. Third, it makes bar association membership voluntary and eliminates mandatory continuing fees beyond initial licensure. And fourth, it creates a legal licensing board with mixed appointments from the governor, the legislature, the Supreme Court, and the public to administer licensure. Fifth, and this is critical, the bill preserves the Supreme Court's constitutional authority over practice before the courts. It includes a constitutional savings clause so that if any portion is found to conflict with judicial authority under Part 2, Article 73A, the remainder continues to function. The bill covers general practice, legal advice, drafting documents, negotiating on behalf of clients, representing clients in administrative proceedings, and encourages judicial deference to legislative licensure standards while respecting the court's role. Mr. Chairman, more pathways to the bar means more lawyers. More lawyers means greater access to justice. Free market principles can make it easier to become a lawyer and easier to afford one. I ask the committee for an not to pass recommendation. Thank you.
Questions for this witness? Seeing none, thank you very much.